We are from Group 5 and today we will be presenting on home insurance. The policy we have chosen is the Home Guard policy by Allianz General Insurance Company Malaysia Berhad. Our group members consist of Muhammad Fakhri Aiman, Darriell, Nur Aisyah, Khairunisa, and one Nurul Nasreen.
Malaysians often seem taking up insurance relating to the property, such as houses. There are tons of available home insurance policy being provided by insurance companies. One of them is Home Guard Insurance Policy. It is an insurance policy that was provided by Alliance General Insurance Company Malaysia Berhad. This insurance policy provides coverage and protection for policyholder, household content, and personal effects. It is also covers damage caused by fire, lightning, explosion, aircraft damage, bursting or overflowing of water tank or pipe or any perils mentioned in the policy.
Formation of contract.
It has been acknowledged in the case of Prudential Insurance Co. and Inland Revenue Commissioner that all insurance contracts must provide some benefit to the insured in the event of a particular event involving an element of uncertainty which is prima facie adverse to the interests of the insured. The need for a level of uncertainty recognized in all insurance contracts to exist is characterized by the fact that those events that are considered certain cannot be insured. This is because the risk involved in the insurance contract must be beyond the control of the insurer, and the insured cannot recover due to his own intentional wrongdoing. Lastly, the insured party must have an insurable interest towards the subject matter of insurance. To form an insurance contract, there must be three elements to be fulfilled. There are offer, acceptance, and consideration. The offer is made through the proposal form, which is to be filled by the person applying for insurance or their agent or representative. The acceptance can be proven through four ways, namely written, policy or cover note, acceptance of premium, and the conduct of the insurer. Thirdly, for consideration, it can be proven through payment of premium by the insured party and through the payment of money during the occurrence of insured events by the insurer. Therefore, once the three requirements are fulfilled, the contract of insurance shall come into force. This is also applicable to the Home Guard insurance policy, where it is stated in the policy that when the insured is desirous of effecting an insurance with the company and has made to the company a written proposal and declaration which shall be deemed the basis of this contract and be considered as incorporated herein. The Home Guard policy also stated clearly that in consideration of the insured paying to the company the premium, the company will subject to terms, exceptions, limits, and conditions in the event of any of the mentioned contingencies happening during any period of insurance and within the situation of risk stated by payment, reinstatement, or repair, indemnify or compensate the insured. The whole point of this transaction is to obtain a legally enforceable cover and to create legal relations.
Insurable interest.
Insurable interest is defined in the case of Lucena and Crawford as the legal right to insure arising out of a financial relationship recognized by law between the insured and the subject matter of insurance. The elements derived from this definition are that there must be subject matter of insurance in existence, the policyholder must have financial interest in the subject matter of insurance, the interest must be a current interest, not merely an expectancy, and that the interest must be a legal interest. Insurable interest is required in every contract of insurance, which otherwise would render the contract invalid. The first element is the subject matter of insurance, which is defined in the case of Castellan and Preston as not the bricks and materials used in building the house, but the interest of the insured in the subject matter of insurance. Insurable interest is the interest which a person has in property which they own because destruction of or damage to the property will cause loss to the owner. Economic and financial interests establish the need for a relationship between the insured and the subject matter of insurance, where the insured suffers financial loss if the insured event occurs. Secondly, the interest must be capable of financial or monetary valuation as opposed to emotional attachment. Thirdly, the English law requires that a person has a current or present interest in the subject matter of insurance. A mere hope or expectation of acquiring an interest in the future is not enough. This can also be seen in the leading case of Lucina and Crawford, where the court held that the commissioners had no interest in ships which were lost before they did so, and that they had merely an expectancy of taking charge of the vessels. Lastly, the English law also requires the existence of a legal and equitable interest between the insured and their property for which they are proposing for insurance. This is laid down in the case of Makora and Norton Assurance Co. Limited, where the House of Lords held that the insured had an interest in his shares but none in the timber which was now owned by the company, which is a separate legal entity. The fact that the insured would clearly suffer an economic loss as a result of the fire because of the value of his shares would go down was regarded as insufficient to give him an insurable interest. Under the Home Guard policy, the company will indemnify the insured against loss or damage caused by any of the perils mentioned in the policy. Therefore, for the insured to have an insurable interest under the Home Guard policy, the elements are to be fulfilled. The subject matter, such as the household goods or personal property, among others as listed in the policy, must exist. Secondly, the insured must prove to have an economic or financial interest in the subject matter of insurance. For instance, the policy covers the loss of cash due to theft, fire, or any other perils. When such event occurs, the insured will suffer financial loss. Therefore, there is a relationship between the insured and the subject matter of insurance, thus the financial interest is established. Thirdly, the insured must prove to have current or present interest in the subject matter of insurance and not merely an expectation to acquire an interest in the future. And lastly, the insured must prove the interest to be a legal interest and not only an economic interest, as it is insufficient to give the insured an insurable interest.
Duty of disclosure.
The first one is the definition. So, an insurance contract is based upon utmost good faith, mutual trust and confidence between the insured and the insurer. It requires both parties to disclose each other all information which would influence either party decision to enter into the contract. The starting point is in the case of Carter and Boehm, 1766. In the case of Carter and Boehm, Lord Mansfield stated, insurance is a contract of speculation. The special facts upon which the contingent chance is to be computed lie most commonly in the knowledge of the assured only. The underwriter trusts to his representation and proceeds upon confidence that he does not keep back any circumstances in his knowledge to mislead the underwriter into a belief that the circumstances does not exist. Next is for limitation for duty of disclosure. There are a few cases that we can discuss on the limitation for duty of disclosure. The first one is Joey and Law Union and Crown Insurance Co. 1908, where Fletcher Moulton LJ stated their duty is to disclose and you cannot disclose what you do not know. Next cases, Leachman and Lancashire and General Assurance Co. Ltd. 1927, where Viscount Dudedin stated the law has often been stated, but perhaps it is just as well to state it again. A contract of insurance is denominated a contract subirime fide. The next cases is Toh Kin Lian and another, and Asia Insurance Co. Ltd. 1996, whereby Elizabeth Chapman stated it is a general principle of insurance law that an insured is under a duty to disclose material facts, and the absence of a proposal form does not modify the assurance duty. The next part is failure to disclose. So failure to disclose material information gives the other party the right to avoid the contract. So the first case is Bank Kisa Ulman SA and Scandia UK Insurance Co. Ltd and others 1987. So such duty requires the insurer to disclose all facts known to the insurer which are material either to the nature of the risk sought to be covered or the recoverability of a claim under the policy which a prudent insurer would take into account in deciding whether or not to insure with that insurer. So the next case is Koh Choi Lang and Public Life Assurance Co. Ltd. 1964. It was held that the case was dismissed on the ground that there is no element of verime fide during the disclosure of material fact to form the contract. For one-ounce of proof, the legal burden of proving non-disclosure of a material fact rests upon the party alleging the non-disclosure. So the first case is Chia Shu Hoon, an American Home Insurance Code 2001. The defendant had failed to show any defense on the merit. The affidavit evidence showed that the agent for the defendant had from inception knowledge of the fact of the theft of the plaintiff's other vehicle. The defense of non-disclosure of material fact entitling the defendant to repudiate liability under the relevant insurance policy therefore failed. The next case is Goh Choi Lang and Public Life Insurance Co. Ltd. 1964. It is a tried law that a contract of insurance is a contract of verime fide which can be avoided for non-disclosure of material facts. In Malaysia, for duty of disclosure, Section 129 of the Financial Services Act 2013 provides that, first, Schedule 9, pre-contractual duty of disclosure and representation for contracts of insurance in Part 2, and the remedies for misrepresentations relating to contracts of insurance in Part 3. Next one is under paragraph 11 of Schedule 9. Any person who contravenes the duty of disclosure commits an offence and shall be liable to imprisonment not exceeding 5 years or fine not exceeding 10 millions or both. Schedule 9 also contains a full statement of the law and misrepresentation and non-disclosure in relation to insurance contracts. It makes a clear distinction between consumer insurance contracts and non-consumer insurance contracts. So in the Home Guard policy, the first one is the consumer insurance contract. Pursuant to paragraph 5 of Schedule 9 Financial Services Act 2013, if the insured that had applied for this insurance only for purpose unrelated to the insured trade, business, or profession, the insured had a duty to take reasonable care not to make a misrepresentation in answering the question in the proposal form and also to disclose any other matter that the insured know to be relevant to the company decision in accepting the risk and determining the rates and the terms to be applied. Otherwise, it may result in avoidance of contract, claim denied or reduced, terms changed or varied, and contract terminated. And the duty of disclosure continued until the time the contract was entered into, varied, or renewed. Next is for the non-consumer insurance contracts. So pursuant to paragraph 4.1 Schedule 9 Financial Services Act 2013, if the insured had applied for this insurance for purpose related to insured trade, business, or profession, the insured had a duty to disclose any matter that the insured knows to be relevant to the company decision in accepting the risk and determining the rates and the terms applied, and any matter a reasonable person in the circumstances could be expected to know to be relevant. Otherwise, it may result in avoidance of contract, claim denied or reduced, terms changed or varied, and contract terminated. This duty of disclosure continued until the time the contract was entered into, varied, or renewed.
Subrogation.
Firstly, I'll be explaining on the definition of subrogation. So subrogation is to allow the insurer to use the insured's name to recover such payout from the tortfeasor or contract breaker. So in common law, subrogation ensures that the insurer stands in the place of the insured once having indemnified the insured victim and takes over the insured victim's right of recovery against the third party who have caused him injury or damage. So in the case of Castellan and Preston, the judge defined subrogation as between the underwriters and the assured, the underwriters is entitled to the advantage of every right of the assured. So this means that after the insurers indemnify the insured, by way of subrogation, it gives the right of an insurer to stand in the place of the insured that was indemnified. So subrogation is to prevent unjust enrichment of the insured, which is to prevent him from unfairly profiting from his loss and to preserve the principle of indemnity. So in the case of Castellan and Preston, the judge stated that subrogation is a doctrine in favor of the underwriters or insurers in order to prevent the insured from recovering more than full indemnity. Now I'll be explaining on the position of the doctrine of subrogation in common law. So in common law, the insurers must first indemnify the insured before they can exercise their rights of subrogation. So this means that the insurer can only insist that subrogation action be taken after they have settled the insured's claim under this policy. So in the case of Scottish Union and National Insurance and Davies, the insured had an accident to his car and the insurers had paid to the motor vehicles repairer €409 to repair the insured's car. However, 3 attempts were made to repair the car, but the work was not satisfactory. At the same time, the insured sued the person who caused the damage and recovered €350 which he used to get the repairs done properly. So the motor insurers then attempted to claim the sum of €350 by way of subrogation. So in this case, the Court of Appeal held that the insurers were not entitled to recover the sum of €350 by way of subrogation as the insured had not been indemnified. In the case of Rafia binti Bakar and East West Umi Insurance Berhad, the judge stated that subrogation is not an automatic process given to the insurer by his insured so as to place in a position to be entitled to the advantage of all rights and remedies which the insured has against the third party in respect of the subject matter. There must be formal assignment of the right of action, and an insurer cannot, in the absence of such formal assignment, bring an action against a third party in their own names. Thus, it's clear that the insurers must first indemnify the insured before they can exercise their rights of subrogation. However, these rights can be modified by way of the subrogation clause in insurance contracts, as they are common law rights and not statutory rights, which will allow them to exercise the rights of subrogation the moment an insurance claim is submitted. Next, I'll be explaining on the operation of the doctrine of subrogation. So the principle of subrogation may be called into operations under two circumstances. So the first circumstance is when the insured have recovered the loss twice, in which the insured have collected payment from the insurers and also recovered compensation for the same loss from the negligent party. So in this case, the insurers can call upon the insured to pay back to them the profit that has resulted from the double recovery. If the insured would be guilty of unconscionable conduct, if the insured does not ensure that sums paid by the third party are handed over to the insurer. So in the case of Teo Kim Kian and others and Lai Sen and another, the federal court held that if damages suffered by the insured himself had been settled and paid to him by the insurer under the policy of insurance, the doctrine of subrogation still applies, and the insurer may require the insured to take an action against the wrongdoer for the recovery of all damages flowing from the wrongdoer's negligence. So if the action succeeds and he recovers a sum entitlement of his claims, the insured is bound to refund to the insurer what the insured had paid to him under the policy of insurance. So the second circumstance is when the insured had not received compensation from another source. So the insurers who have indemnified the insured in respect of the loss may themselves bring an action against the third party who is legally responsible for it. In the Home Guard policy, the insurance company has included a subrogation clause in which the company will be entitled to use the name of the insured in bringing proceeding against the other person to recover compensation for the loss in respect of the risk insured under this policy, including the domestic medical assistance program that forms part of this policy. So the company shall be entitled to all rights of subrogation, whether by way of indemnity or otherwise. Thus, this clause allows the insurance company to operate the doctrine of subrogation under the two circumstances as I have explained earlier. So firstly, if the insured has recovered the loss twice, he is bound to refund to the insurer what they have paid to him. Secondly, where the insurer has indemnified the insured as they have not received compensation from any other source, the insurer may themselves bring an action against a third party who is legally responsible for it. In the Home Guard policy, it was also stated in the subrogation clause that in a claim by way of subrogation by the insurer, the insured shall give all the information and render all assistance in the insured's power and free of expense to the insurance company. So as I have stated earlier, in common law, the insurance company is required to indemnify the insured before they can exercise subrogation rights. However, this common law right can be modified by including a clause which requires the insured to begin proceedings against a third party the moment the insured submits their claim. However, in this Home Guard policy, such clause was not inserted, but the insured is still required to begin proceedings against a third party, as it is stated that the insured shall render all assistance to the insurance company in exercising their subrogation rights.
Double insurance and contribution.
Double insurance, and how is double insurance related to the doctrine of contribution? Double insurance is commonly practiced by individuals who incline to take up any insurance policy. This means the person insured a risk or subject matter with two or more insurers. There are no law that prohibit an individual to insure a risk with more than one insurance policy, but the insurer can add their own exclusion clause in the policy. If both of the policy contain the same clauses, then the clauses will automatically cancel each other, making the insured capable to claim from any or both policy. This situation will create the doctrine of contribution. However, this doctrine cannot be used with a life insurance policy. Now we move to the element of double insurance and the application of the doctrine of contribution. The first element need to be fulfilled is there are two or more policy existing at the time of loss. This means both policy must have been valid and not terminated at the moment the loss happened. The second one is the contract must be valid and enforceable. This means the insurer has no right and cannot avoid to excuse themselves from executing the contract. And third element is all the policy must have a common subject matters. However, it does not mean that it need to be identical to each other, and it is also considered to have a common subject matter when the policy have a sort of overlapping terms. Now we move to the fourth element. All the policy are concerning a common risk or peril, but it does not need to be identical and it's enough if it's overlap with each other. So in the case of American Surety Co. of New York and Brightson, Justice Hamilton held that an insurance that covered dishonesty of employees was held to be in contribution with the other policy covering dishonesty of employee and burglary. In this case, dishonesty was considered as the common peril, and a common subject matters can also be in a form of legal liability. And the final element is all the policy need to have a similar insurable interest, and it must cover the same interest. North British and Mercantile and Liverpool, London and Globe Insurance 1877, the owner of a deposit of grain had a policy of fire insurance covering the grain. So, to had the bailey who was responsible for it. The grain was burned down during fire. The liability having been attributed to the bailey insurer paid the claim, but failed to recover a contribution from the owner insurer because the insured interest of the grain was different one from the bailey and the owner. In this case, it was said that the risk insured and the person insuring must be the same. As I mentioned before, there are no law prohibiting an insured parties to take out more than one policy, but there can be some exclusion clause made by the insurer. The first one is restraining clause, where the insured is restrained from taking another similar insurance policy with another insured. Second one is the excess clause. It will allow the insurer to only pay excess from the paid policy in order to give indemnity. Third is rateable proportion clause, where the insured have the right to claim from both insurer on a rateable proportion to prevent unjust enrichment. Fourth is the insurer can provide more specific clauses in the insurance policy, and it will provide a smaller view on what type of loss will be recovered. And last type of clause is notification clause. The insurer need to notify the insurer if they have other insurance policy that cover the same matters, or they are taking another policy while the other one is still valid. Now we look into the home guard policy. The home guard policy has a general condition on contribution, where it was stated at the time of the happening of any loss or damage covered by the policy, and there are substituting insurance policy of any matters covering the mentioned property insured, or any part thereof, whether affected by the insurer or not the company of the insurer, that shall not be liable to pay or contribute more than its rateable proportion of such loss and damage. The company will not compensate the insured more than the rateable proportion when there is a presence of another policy concerning the same property, and in home guard policy the common matters is the house. Next, in home guard policy there are presence of notification clause. The insured are required to write a notice or to notify all the insurer that is affected by the insurer or on the insured behalf, covering the property or any part of the property upon the happening of any such loss or damages. It was also stated that no claim under this policy shall be payable by the insurer until such notice have been received by the insurer. This notice shall be the duty of the insured to make sure all the insured know about the other existing insurance policy, and to avoid the insurer gaining any profit from the claim that was made.
Insurance intermediaries.
Commonly, insurance transactions between the insurer and the insured will be represented by insurance intermediaries, who are agents that will facilitate the formation of the contract between its principal and the third party. This is known as the principle of agency. In Section 135 of the Contracts Act 1950, it outlines that agents are those representing others in dealings with third person, and the person whom the agent is representing is called as principal. So, who are the insurance intermediaries or agents in insurance law? We can refer to Section 2 of Financial Services Act 2013, where there are generally two groups of insurance intermediaries. Firstly, insurance agent, and secondly, insurance brokers. Insurance agents are those who is acting on behalf of the insurer in insurance dealings, such as solicits or negotiates a policy with the insured. However, on the other hand, insurance brokers are also an agent, but instead of acting on behalf of the insurer, insurance brokers act on behalf of the insured, because they are independent contractor and is not bound with any insurance company. Hence, Financial Services Act 2013 has draw a distinction between insurance agent and insurance brokers. Next, according to Schedule 9, Paragraph 12 of the Financial Services Act, the knowledge of the insurance agent shall be deemed to be the knowledge of the insurer. A statement made or an act done by the insurance agent shall be deemed to be a statement made or an act done by the licensed insurer. Exception is where there is collusion or connivance between the insurance agent and the proposer in the variation or formation of the contract of insurance, or where a person has ceased to be an insurance agent of a licensed insurer and that insurer has taken all reasonable steps to inform the policy owners of the fact of such cessation. So what does this mean? It means that the insurer shall be liable of any misrepresentation or action done by its agent, regardless of whether it is known or allowed by the insurer. In the case of Pertama Makmur Sdn Berhad and Hong Leong MSIG Takaful Berhad, the plaintiff has purchased a policy from the defendant where the plaintiff has paid a premium to the defendant's agent. A risk has occurred that causes loss which is covered under the policy. However, the defendant claimed that they are not liable as the payment was not received by them. The court decided that the defendant is liable for the action of their agent. Payment made by the plaintiff to the agent is deemed as payment made to the insurer. Therefore, the action of the agent is deemed to be the action of the insurer. On the other hand, action of an insurance broker will not be deemed as action of the insurer, as the brokers are independent contractors and not acting on behalf of the insurer. Instead, they act on behalf of the insured. This is reflected in the case of Mersiniaga Sdn Berhad and Union Insurance Malaysia Sdn Berhad. Under the Home Guard policy, Schedule 9, Paragraph 12 of the Financial Services Act is applied, where it is stated that any premiums paid to the insurance broker is not deemed to be payment to the insurer. If the insurance is transacted through the insurance broker, the broker is acting on the insured's behalf for the purpose of formation of this contract of insurance. It is important for the insured to ensure the insurance broker remits the premiums to the insurer. Where the premium payable is received by an authorized agent of the insurer, the payment shall be deemed to be received by the insurer, and the onus of proving that the premium payable was received by a person, including an insurance agent who was not authorized to receive such premium, shall lie on the insurer.
Loss and claims.
A claim begins with the notice of an incident causing injury or loss to the property or the death of the life insured by the insured or their agent. Notice must be in writing if it is explicitly mentioned in the insurance policy. If no such condition exists in the policy, the notice can be communicated verbally to the insurer. The duty to comply with the written notice is unambiguous when the terms of the condition of the requirements are also unambiguous in the contract. The insurance claim officer will ensure that firstly, the claims falls within the period of insurance, and secondly, the perils causing the claim reported are generally within the scope of coverage and is not excluded by any clear exclusion clause or policy condition. A notification of claims clause or condition with a specified time may be considered a condition precedent to liability, requiring strict compliance. In the case of Pacific and Orient Insurance SB and Qatir Value, there is a condition in the policy that stipulates that the notice of claim must be given within 14 days after the incident which raises liability occur. The court decided that the defendant had failed to show that the condition is precedent to liability. Therefore, by applying contra preferentum rule, contractual clause which is ambiguous is interpreted against the contract maker. Hence, the insured is entitled to the claim. This means that if a condition is precedent to liability, is proved by the insurer and it is not performed by the insured, then the insured cannot make a claim. Hence, it is important for the insured to make a claim within the time specified in the policy. On the other hand, if there is no time specified in the insurance contract, but it was stated that the notice must be made as soon as possible or immediately, the court will take into account the facts and circumstances of each case, as was decided in the case of Aspen Insurance UK Limited and Factor Limited. We can also refer to the case of Darriell's Administratic and Motor Union Insurance Co., where a claim was made to the life insurance of someone that has died a year before. It was held that the claim is accepted, taking into consideration that the existence of the insurance policy was only recently known by the beneficiary and claim was made as soon as it was known. Therefore, if there is no time specified, claim must be made in a reasonable time and not exceeding the Limitation Act. There are some instances where terms are not described as such to be conditions precedent to liability. Under the Home Guard policy, notice must be given immediately in writing after the risk insured occurred. If the loss incurred is due to death or other criminal act, notice must be given to the police and all reasonable assistance must be rendered for the purpose of discovery and punishment of any guilty person and the tracing and recovery of the injured property. Without the written consent of the company, the insured is not allowed to repair, reinstate or dispose any property insured, which is the subject of a claim under this policy. Since there is no specified time to give a notice of claim, the insured shall give the notice within reasonable time, as the policy stated that it must be made immediately. If any of these conditions are not strictly followed, the insurer may repudiate liability to indemnify the insured if the insurer managed to prove that the provisions are conditioned precedent to liability. Next, the insured must provide evidence that are needed to prove loss have occurred as a result of the occurrence of protected perils. In the case of Tang Tun Tian and United Oriental Assurance Syndrome Berhad, it was held that the burden of proof lies on the plaintiff on balance of probabilities to prove that the damage on his car was insured perils. To prove the amount of loss, the insured is required to submit proof of loss, which could be in the form of receipts for purchases or certificates of ownership. When the cause of loss is a series of events and one of the events is an excluded peril, then the law needs to determine whether the loss was caused by an insured peril or the excluded peril. Under the Home Guard policy, all relevant documents must be provided in support of the claim within 14 days after such notice has been given to the company. This means that a notice of claim must be made immediately to the company, and within 14 days after the notification of such claim, all relevant documents must be provided in order to support the claim. Next, for the doctrine of proximate cause, it looks at the most dominant and effective cause of loss, and there was no intervening event that breaks the chain of causation until the occurrence of the insured perils. In the case of Etherington and Lancashire and Yorkshire Accident Insurance Company, the policy covers accident peril. The insured died because of pneumonia, as he needs to ride the horse in wet condition after falling off his horse onto the snow. The court decided that the chain of causation was not broken, as the accident is the most dominant cause of the insured's death and the plaintiff is allowed to make a claim. Where attempts to reduce damages are undertaken by the insured and harm is incurred in the process, the following losses or damage may be protected by the insurance policy as part of the function of the hazards or dangers covered by the insurance policy. Under the Home Guard policy, the insured perils and excluded perils are clearly mentioned in the insurance policy. Insured perils include fire, lightning, thunderbolt, subterranean fire, explosion, hurricane, cyclone, typhoon, and windstorm. Excluded perils include war, invasion, act of foreign enemy, hostilities or warlike operations, mutiny, military or popular rising, insurrection, rebellion, revolution, and any act of terrorism. Next, falsification of evidence such as documentary evidence in the form of receipts, invoices, and photographic evidence, or the presentation of some other falsified or false records would constitute fraud. If a claim contains a statement which the maker of the statement knows to be untrue, that statement is fraud, and this includes active concealment of a fact which would highlight the truth. In the case of Sinayah and Sons Sdn Bhd and Damai Setia Sdn Bhd, once the insured has submitted evidence in support of their claim, the insurer who suspects that the evidence is submitted in falsehood with an intention to deceive has a duty to prove that on the balance of probabilities the insured has committed fraud. Liability of the insurer to indemnify the insured can be repudiated when there is no loss as reported, the loss was not caused by the insured peril, the claim was fraudulent, or the policy was void due to breach in condition. Otherwise, the policy money will be paid for contracts of indemnity. In the Home Guard policy, it is stated that the policy shall be void and all benefits forfeited if any claim is fraudulent or based on exaggeration or false declaration. The company shall not be liable for loss attributed to the act of cheating by any person. This includes death by deception, which means the insured deceive a person to cause damage to the property. Therefore, a claim may be rejected on the ground that the claim is fraudulent and insurer can repudiate liability.
So in conclusion, the Home Guard insurance policy is an outstanding policy that uses all the relevant principles to form the policy. This policy is also in line with the Financial Service Act 2013 and Malaysian Insurance Law Principle. That's all from us. Thank you.